Does Matthew Tuttle need to be brought up? Yes.
Probably. Should we set it for jury trial today?
Yes, but I believe it's a plea. And then, so if we could get him brought up when.
All right, so Megan, if you can get Matthew Tuttle.
Absolutely.
And we'll bring him up. He was set for jury trial today.
From there, I believe we can go ahead on Tammy Banovic.
Morning, Your Honor.
Good morning, Mr. Harris, I should say. All right, so we're on the record in docket 25-02299. That is People of the State of Michigan versus Tammy Banovic. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ellis is the prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Tammy Banovic, who is standing to my right, Your Honor.
And ma'am, you are Tammy Banovic, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a final pretrial in the matter. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date. They did contact me on Friday and left me a voicemail stating that, or asking to have, but that permission was not granted, as I did not have time to ask for that permission from the court and from defense. So at this time, Your Honor, I do believe there will be a motion from the defense.
Mr. Harris.
Yes, Your Honor. Given the complaining witness's failure to appear at the final pretrial today, I would be requesting if the court would dismiss this case at this time and provide a copy of that dismissal to my client.
All right, so I will entertain the dismissal without prejudice on motion made by defense. But Ms. Banovic, usually this is a default dismissal without prejudice. This could start again depending on if the victims come and want this restarted. And so this all may start again. You should be aware of that I'm dismissing without prejudice with the understanding that the victim can request that this be, they'd have to meet with the prosecutor, Mrs. L, and prove that they're willing to go through whatever it takes. But we will dismiss without prejudice for today's purposes, and I'll draft Mr. Harris to grab the nollie pros. That's a fair statement, Mrs. L.
It is, Your Honor.
Yeah.
Permission to approach?
You may. Thank you. All right, so I am at the defendant's request for the dismissal on case 25-02299. This is dismissed, of course, dismissed. This is without prejudice, which is really our default. That's how we default this setting. I will sign the dismissal without prejudice accordingly. And anything else for the record in 25-02299, Mrs. L?
Not for the people.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Ms. Banovic, I don't see any orders that would be that would require a copy to be carried with you. There's no contact, or I don't think I'm out of state, or no travel out of state. So you should be all set today, ma'am. All right.
All right. Thank you.
All right, thank you. Who's next, Mrs. L?
I believe we are ready on Ms. Moore's case and on Ms. Abdullah Mir.
So what was the first one, Mitz?
Moore.
Moore.
This is Ms. Moore, Your Honor.
All right, so we're on the record in docket 23-00366. That is People of the State of Michigan versus Oyana Moore. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ellis, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Moore, who is standing to my right, Your Honor.
And ma'am, you are Oyana Moore, is that correct? All right, thank you. This is the time set for a violation of probation hearing. Mrs. L, how are we proceeding?
Your Honor, if I could defer to Mr. Harry.
Mr. Harris.
Yes, Your Honor, when I spoke with Ms. Moore, well, I guess the first concern I had was, according to the documents that were provided, it seems like her probation was scheduled to end on August 4th, 2025. And to the best of my knowledge, there weren't any orders of the court extending that date. And then the the request and summons for probation violation was drafted by probation on August 6th and signed by the court on August 7th, which
Would you
To my-
state the
yeah.
probation buttons?
and to my knowledge, that would be after probation had already ended if it wasn't extended by the court. I do understand that sometimes when there are probation violations, the probation can be extended, and sometimes is extended past that date to allow time for the hearing to occur or any other court dates on that violation. However, as far as I can tell, the violation in this case wasn't even issued until after that probation date had already ended. So
This was non-reporting probation for restitution purposes.
yes, my understanding regarding that is that Ms. Moore has been trying to make at least some payments, but has been experiencing a bit of financial difficulty, Your Honor. My simple request, I guess my first request today would be if the court would consider, given that the probation end date has already passed, if the court would simply just discharge from probation and refer the fines and costs to collections so that she can make whatever payment arrangements she needs and whatever payment plan with collections.
I think that is the actual request. Yeah, is discharge from probation. So that is my reading of this. And Ms. Moore, this is why we give you counsel, okay? So you can go through all the paperwork and see, and we can see like, okay, there is a problem here. And the problem is that your probation actually ended August 4th. And then any allegations were after that. But this is an easy fix, I think, because you were put on probation to collect the restitution. So that's the nature of it. So we'll do a formal discharge from probation. And then any residual concerning restitution, which I have a little over $1,000, is sent to collections. So to keep you out of the show cause cycle, keep in contact with collections. I believe it's Marquita. Anybody on the counter could help you. Because if they don't know if you're not paying or you simply can't afford to pay, they will show cause you. And then if you don't show up for show cause, a warrant's issued for you. Okay. So that you want to stay out of that cycle. All right. So I'm discharging from probation and referring the matter to collections. Anything else for the record in 23-00366, Mr. Harris?
Nothing from the defense, Your Honor.
All right. Do you have any questions of me, Ms. Moore?
No, thank you.
You should be all set. Thank you. Google. Ready on Dina?
Yes, if we could. And then we'll go on.
Abdul Lamir.
I'm sorry, can you use transport?
That's what.
We'll go on Mr. Need's case or not. All right, so we're on the record in docket 25-01759. That is People of the State of Michigan versus Dina Abdul Lamir. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Fellow, Assistant Prosecutor for the people.
Mr. Reed.
Good morning, Your Honor. Tim Reed on behalf of Dina Abdul, and she's staying to my right.
Ma'am, correct my pronunciation. You are Dina Abdul Lamir.
Yes, Your Honor.
Right, thank you. This is the time set for a plea today. I'll have Mrs. Alhawi proceeding. You might have to reiterate what the plea was.
Thank you, Your Honor. At this time, the people have extended the plea offer of a retail fraud third with a promise to pay restitution. That plea offer does come with a Killebrew agreement of no upfront jail and an agreement to HIDA. I do believe today that plea offer will be accepted, and I can grab the pack codes in just a second.
All right, so that's amended count 1
Yes, Your Honor.
of retail fraud in the third. So that's under $200.
Yes, Your Honor. And that would be under MCL 750.356D4. And that is a 93-day misdemeanor and or a $500 fine
There's the Killebrew agreement of no upfront jail.
and agreement to hide it. The restitution in the amount is $201.50. That would be to Target. We can, I believe we can fill out a pink sheet for that today.
Is that your understanding of the plea offer, Mr. Reed?
Yes, Your Honor.
All right. Mr. Reed, may I inquire of Ms. Abdul-Amir for advice of rights, for misdemeanor advice of rights?
Yes, Your Honor.
Okay. All right. Ms. Abdul-Amir, you understand that the plea agreement is to amend to count 3, amend count 1 to retail fraud in the 3rd degree. That's that punishable by 93 days under $500 is the ultimate punishment. There's a Killebrew agreement between Mr. Reed and the people of the state of Michigan that you receive no upfront jail and HIDA status. All right. And HIDA status is for the court is really just a different way of abstracting, but it means that this doesn't appear on your record. All right. And then restitution to Target for $201.50. Is that correct? All right. You understand in this misdemeanor plea, you have the right to be tried by a jury, to be presumed innocent till proven guilty. You have the prosecutor prove beyond a reasonable doubt that you are guilty. You have witnesses against you appear at trial. To question any witnesses that are brought against you, you are represented today by attorney Timothy Reed, and he would be present, Patrick Reed, I should say. Patrick Reed, and you should be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am? You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim to plea as a result of any promises other than what we put on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the retail fraud in the 3rd misdemeanor instead. Is it still your wish today to plead guilty to the retail fraud 3rd misdemeanor instead? Have you raised your right hand? Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm going to bring your attention back, ma'am, to March 7th, 2025 at the offense location, 500 East Edgewood Boulevard in the city of Lansing. Were you at on March 7th, 2025? Were you at 500 East Edgewood Boulevard in the city of Lansing in Ingham County?
Yes.
And that's commonly referred to as Target. Is that correct?
Yes.
All right. And was Target open to the general public? And at that time, were you responsible for taking items that were for sale at Target, but you didn't pay for those items less than $200? And that was your intent, ma'am. Is that correct?
Yes.
Anything else for the record, Mrs. Evans?
No, Your Honor. Thank you.
Mr. Reed.
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. I think we'll probably refer to probation just for the HIDA because they'll come back and they'll tell me, they'll take a look at it because that's a special designation status. If Mrs. L indicates there won't be any issues, I don't think there'll be any issues, but I think it's got to come back from probation for that status.
I believe that's correct, Your Honor.
So let's refer to probation. And you have a pink sheet and I can stick it in the file.
May I approach?
You may. That's an easy one to order if probation says that's fine. They'll just go through. So we'll set sentencing date of
November 25th at 1:30.
November 25th at 25th at 1:30. Does that work for your schedule, Mr. Reed?
Yes, Your Honor.
All right. All right. So we will send probation as one floor down all the way to the right. They may see you now. They may set up a meeting, since I think this would be a pretty quick meeting with you. Anything else for the record in 25-01759, Mrs. L?
Not for the people. Thank
Mr.
you.
Reed?
No, Your Honor. Have a good day.
You too. We'll see you. We'll see you on November 25th.
Thank you.
Thank you.
Thank you.
Tuesday after Thanksgiving.
Tuesday before Thanksgiving.
Is it? We have Mr. Ned.
Here, he is here.
Are you ready in your case? Mr.
Yes,
Ned?
Your Honor.
What case are we calling next, Mrs. L?
Your Honor, I believe we could call the Matthew Tuttle case.
Bring up Mr. Tuttle?
No.
Oh,
He refused transport, Your Honor.
You say that with a stomach.
yeah, how do you say that with a straight face? That's hard. It's hard to say with a straight face. All right. So we're on the record in 25-00223. That is people of the state of Michigan versus Matthew Tuttle. This appearance is for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Isabel, Assistant Prosecutor for the people.
Mr. Ned.
President Aiken, on behalf of my client is not here today, Your Honor.
All right, thank you. This is the time set for a jury trial. It was scheduled for 8 o'clock. It is now 9:07. It would appear, Mr. Tuttle, we know where Mr. Tuttle is. He's in lockup. He's been incarcerated. We did attempt to bring him up, to bring him over, and to get him brought up, and Mr. Tuttle refused at that time. So there may be some mental health concerns with Mr. Tuttle. Mr. Ned, have I covered everything that so far that this was set for jury trial, and we know where Mr. Tuttle is? He just refuses to participate at this time.
That's correct, Your Honor. I would just ask the court to reset the jury trial date for another date. It's my understanding today was going to be a plea date.
That's my understanding too.
So I will notify the court prior to the next court date if he changes his mind, which could have been the situation. Without getting too much detail, the plea was against my advice. So maybe it was a change of his mind without confirming with me. So
Yeah, I don't know. He just wouldn't get on the transport, I guess.
Mr. Annette said that this was a plea deal and we did not need to call the jury.
Yeah. So the last report we got was it was a plea deal, and
correct.
we don't have to call in a jury. So how would you like to proceed?
Your Honor, honestly, if we could have it set for a plea date, and then if that plea falls through at that time, set it for a jury trial, I think that would be a better option. The people would also potentially be open to this being set for a hearing that maybe Mr. Tuttle could appear via Zoom if transport continues to be an issue.
Yeah, we can set it for plea date, make it Zoom appropriate. How's that?
Whatever
He can
works.
plead, yeah, he can plead. This is a retail fraud
Second degree.
second, and he can plead by Polycom if this is still an issue. But if Mr. Tuttle doesn't join us by Zoom or doesn't tell us, then there could be a fail to appear because he just won't participate anymore, which I know is not exactly your problem, Mrs. L. It's somewhat your problem, Mr. Ned, but you can't make him come. It's not like you can carry him here. So let's set it for plea date on
10:14.
October 14th at 10:30. I'm going to indicate that Zoom is appropriate. So Mr. Tuttle may be put on Polycom, which comes with its own issues, its own Polycom issues. The second we see Mr. Tuttle, we will call the case. Anything else for the record in 25-00223, Mrs. L?
Not for the people. Thank you.
Mr. Ned. All right, thank you. We're all set. Megan, you couldn't get him up here.
I went down there and they're like, who? We don't even have him on the list. I said, you should have. And then the other one in the back was like, oh, that might have been the one that refused transport. I was like, well, I guess I don't need anyone then.
Right. I'm good, thanks.
Oh, they took his dog.
Back to my
On the Google Pic 6A, you were just letting in the Zoom courtroom. Could you please identify yourself, sir? You have to unmute. Oh, you're gonna have to unmute, sir. I can't hear you.
Kenneth Thomas.
Kenneth Thomas. All right, Mr. Thomas, you're here for your 8 o'clock.
Yes, Your Honor.
All right. All right, stand by. We'll see you. We'll call your case in just a second.
Yes, Your Honor.
That's right. And I should go on the record, but, all right, so, you're arguing this motion for Mr. Thomas, Kenneth Thomas, is that correct?
That's correct, Judge.
All right. And sir, you are Kenneth Thomas, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Mr. Thomas?
Yes, Your Honor.
All right. I didn't realize I was on, we had the court on mute. Everybody has identified themselves. We're arguing the motion on the second file, which is the vicious dog file. And then we'll see how that wraps itself up, or whether that may be indicative of what we do on the final pretrial for the dog at large. But the motion's been filed for the vicious dog case, and that's what we're hearing. All right, sir?
Yes, Your Honor.
All right. Mr. Foreman, you may proceed.
Thank you, Judge. I know I've argued a similar motion in front of you before. I think it was on dog MDOP as opposed to vicious habits, but the same exact logic applies. Last year, Judge Dragonchuk determined that the dog bite ordinance under the Ingham County Animal Control ordinances was not valid because the county did not have the proper authority, had not been granted the proper authority by the legislature to enact such an ordinance. The exact same is true for the vicious habits ordinance. There's nothing in the dog law of 1919 which governs vicious habits, and there's nothing in the Dangerous Animals Act that gives the counties the authority to enact ordinances relevant to the Dangerous Animals Act. The people, I've received the people's brief maybe 45 minutes ago. I've done some, I've tried to read through and tried to understand it. Their primary argument, as far as I can tell, is that my brief didn't, or that our brief only did a cursory treatment of authority and effectively abandoned the issue. Certainly don't see how that's the case. We filed a motion which deals with which outlines the statutory authority or the lack thereof in this case, outlines the general principles of enacting how counties are enabled to enact ordinances, and made clear that in this case the county is not entitled to enact this ordinance. As it relates to everything else in here related to the Dangerous Animals Act and all of that, I think Judge Dragonchuk dealt with the same exact argument from the people last year in the McGrew case and ruled against them. Judge Dragonchuk determined that, and I can read directly from her opinion, had the legislature wanted to delegate to the county the power to criminalize dog bites, it could have done so when enacting what is commonly known as the Dangerous Animals Act. And as concluded by Judge Dragonchuk, I think it's the same here, where vicious habits are not included in any grant of authority from the state to the county. There's been no grant of authority to enact such an ordinance. So I'm happy to leave it there, Judge. If you have any other questions, I'm happy to answer that as well.
I think what we're going to end up doing is, since we have a response to motion to dismiss, it's fairly, I don't want to make you argue something that you just got a response to. So let's, and I'd like to read the entirety of the brief before having the opportunity to rule. Ms. Kachukas, if you want to summarize your brief, but what I'm going to end up doing is adjourning this so that we have some time to both take a look at it and then re-argue both positions. And it's because I've had the time to review or to read the motion to dismiss response. But if you want to supplement it in any way you can, it's entirely up to you.
Yes, Your Honor.
I'm going to provide additional response time and motion time to adjourn it. So if you could, you'll have the chance to do it later, but you can do it now if you'd like. At least start it.
I can give a brief summary just so that the court knows what they're getting into.
All right.
Your Honor, the people's argument kind of falls onto two parts. One is that the defense cites, as Judge Dragonchuk did, the Miller case, and I think that's not necessarily an appropriate case to be citing in this matter, because in the Miller case, that's talking about it's comparing two different sections of an OWI statute, whereas here we're comparing two different entire statutes that are much further apart, and they haven't even been passed in the same year together. So they likely would not have been done in contemplation with one another. That's essentially, Miller is a legislative intent argument as far as I see it. And the legislative intent argument kind of necessitates of digging into the legislative history and that passage surrounding the bills. And I am not going to, sit and do the defense's research for them, but I at least did a cursory review to see at least if anybody who is in the legislature at the passage of the dog law was at least in the legislature or served at the same time as anyone in the legislature as the passage of the Dangerous Animals Act, and that did not occur. The reason I mention this argument is because the legislature is in fact a living body. It's not an all-knowing, omniscient being that's just passing laws. It's humans working together to change laws. And the people's second argument is that there is a clear and obvious gap in the Dangerous Animals Act under Section 3. The defense actually points out themselves in 287.323 subsection 3. It discusses the prior adjudication of an animal as a dangerous animal, but in no part of the Dangerous Animal Act does it say how to previously adjudicate an animal as a dangerous animal. So that's kind of the basic overview of the people's argument, is that the vicious habits is filling that obvious gap, that the only reasonable authority for that to be left to would be the animal control of each count.
All right, and it's for the twofold argument that we'll be adjourning, so we can. I need to read Miller again just to see the inference that Judge Dragonchuk's drawing. But this is based on Judge Dragonchuk's ruling concerning whether there's the authority given to enact the statute. And I believe this is under the county statute, right?
Yes, Your Honor.
All right.
All
right. So adjourn for motion and for further argument. So we can review response and motion. And it would make sense that we do that on both files. Yeah. So we will also set for final pretrial and adjourn docket 25-022-02240 concerning the motion some of these notes are just so for my purposes. And we'll adjourn to
How far out?
how far? I think you just asked the judge how much time do we need to read these briefs? And I know that I'm gone the next 2 weeks, so sometime after that, because I could probably read the briefs in the morning. But if I want to look and dive into Miller, maybe 3 weeks out.
Judge, I'll be out the 13th if you're looking at that date.
Looking at that date.
I'm not looking at that date.
All right, thank you.
My wife would kill me if I was looking for that date.
Should I just in the afternoon, we have time for some testimony?
If it fits everybody's schedule, I don't think we have any testimony. I think this is just to make sure everybody gets the arguments and gets to read the arguments. So, but I mean, it could be 30 minutes of argument or so, I would think.
Let's do October 28th at 10.
So would that work? October 28th at 10 o'clock.
Okay.
We'll check your schedule, Ms. Kachukas, because and then would that work for your schedule, Mr. Foreman?
It does, Judge. Thank you.
I know you're not assigned to this courtroom.
That was 10 o'clock?
Yeah, October 28th at 10 o'clock. All right, so we'll reset this for October 28th at 10 o'clock on 25-02240 and 25-02241. Anything else for the record in either one of those files, Ms. Kachukas?
I believe Ms. Ezell has something.
Yes, Your Honor, if I may. As these are final pretrials, I do believe that Mr. Thomas should have been here in person. From my files, there was no prior permission given for parties to appear via Zoom for today, nor for any final pretrials moving forward. When I did address this with Mr. Harries, I was not given a solid answer about if any permission was given for a Zoom appearance. Your Honor, we would ask that the court rules be followed and that appearances be in person for final pretrial.
All right, now, I have a dog at large and a vicious habits. Do you plan on having your witnesses here?
Yes, Your Honor, for that one, we would actually have the witnesses here. I do believe it's important to have them here.
All right, so if the witnesses are here for the vicious dog habits, we're setting it for final pretrial and motion on both cases. Do you have any objection to Mr. Thomas coming in person for the final pretrial?
No, Your Honor.
Okay, so Mr. Thomas has indicated that he doesn't have any objection to it. Do you have any objection?
I do not, Your Honor. And my
All right.
apologies, I was speaking with another client.
All right, so we'll do live in person. So Zoom would be inappropriate based on the prosecutor's request. Zoom is inappropriate. All right, so Mr. Thomas, be here live in person on the 6th floor for the final pretrial, and then we'll continue on the motion to dismiss, and then the other file, the dog at large file. All right, sir?
Yes, Your Honor.
All right, that'll be on the 6th floor of City Hall of Lansing. Anything else for the record in 2502241 or 40? This is up.
Not good people, thank you.
Mr. Foreman.
No, thank you.
Mr. Harris, you're here on the other file,
Yes.
but that we've adjourned it to go along with the motion.
Understood, Your Honor. Thank
All
you.
right, thank you. You're all set, Mr. Thomas. Thank you for your appearance today.
All right, thank you, Your Honor.
Great.
Thank you, Your Honor.
All right, so Mr. Levine, I'm going to place you in a breakout room with your public defender right after we do this hearing, the hearing right before you, okay? So don't let them make you leave that room. You're going to be in a room with your public defender.
All right, thank you.
All right, and then what's the one from DOC, Mr. Harris?
That's Kenyatta Jeter, Your Honor.
All right. And ma'am, you are Kenyatta Jeter?
Sir.
Sir, you are Kenyatta Jeter?
Yes, sir.
All right, thank you. All right, let's go ahead and call Mr. Jeter's case. All right, so we're on the record in docket 20-1619. That is people of the state of Michigan versus Kenyatta Jeter. Appearances for the record, Ms. Thompson.
Laura Thompson for the people, and I'd like to motion to practice under Michigan Court Rule 8.120. My supervisor is APA Gabrielle Azell.
All right, that's granted. You only may have to make it one time today. Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Mr. Kenyatta Jeter, who appears via Polycom from MDOC, an MDOC facility in Lakeland.
All right, and sir, you are Kenyatta Jeter, is that correct?
Yes, sir.
And you can hear me all right, Mr. Jeter?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how we proceed?
We're requesting that this be sent for a final pretrial at this time.
All right.
Yes,
Is
Your
that
Honor,
your understanding, Mr. Harris?
Yes, Your Honor, that is a correct statement of the facts. I've spoken with Mr. Jeter regarding this case, and I have also discussed with him a likely motion to dismiss the defense may be filing, given the information he has provided to me is that as far as he is aware, and as far as I've been made aware at this point, he likely would have been in MDOC custody at the time this has occurred. I still need to look into that. And his indication is that he's been in MDOC since, I believe, believe the active sentence he has, according to Otis, was that he was sentenced in 2013 and has been there since. And this is alleged to have happened in 2019. I still need to investigate that, Your Honor, but I just wanted to make sure the court was aware and the prosecutor was aware, as this was something that came up during my discussion with Mr. Jeter.
All right, and obviously the prosecutor now faced with a prospect motion dismissed can do their investigation to see if the officer did identify the right person or what the identification was concerning this matter. All right, so is Zoom appropriate for the motion for the final pretrial? Mrs. L. And Ms. Thompson, I should say. I saw you looking at Mrs. L. So.
Yes, Your Honor.
All right, so Zoom is appropriate. I'm going to say for all witnesses and defendant. So Zoom, and so we'll set it for final pretrial, an adjourned final pretrial, so we can have some investigation done on the, if there needs to be a motion to dismiss, or if that would be the right time. But the defendant can attend via Zoom, and any witnesses can attend via Zoom if they choose to. What is the adjournment date?
October 14th at 8:30.
All right, we've adjourned to October 14th at 8:30. Anything else for the record? Zoom is appropriate, so Mr. Jeter, you can attend via Zoom. Anything else for the record in 20-1619, Ms. Thompson?
Not for the people.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. Jeter, we'll see you on October 14th at 8:30. Thank you for your appearance today.
Yeah, thank you.
So you should be all set, sir.
Yeah.
And Mr. Levine, I'm going to place you in with your attorney.
Thank you.
So when you join us, Mr. Harris, you're already here.
Yes.
All right. So you can go back to room 1, and I'll just move Mr. Levine into room 1, and I'll move that. All right, Mr. Levine, you'll be meeting your attorney, and then we'll come back and put it on the record.
That's right.
Then let me look at it. Let me look at it deeper, call a different case. What case are you running?
Fowler.
Okay, just go ahead and call Joshua Fowler.
Joshua Fowler.
Yes, please, sir.
Right here. And on top where it was staring at me. All right, so we're on the record in 25-02516. That is a pretrial on 25-02516 is a pretrial, people of the state of Michigan versus Joshua Fowler. Ms. Thompson, your appearance for the record.
Laura Thompson for the people.
Mr. Ned.
Georgia at APD, I'm back. My client is staying to my right.
And sir, you are Joshua Fowler, is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a pretrial in the matter. First off, there was a letter written to the court. Does everybody have a copy of the letter?
I believe so, Your Honor.
Yes, Your Honor.
From the complaining witness.
Yes, that's from the complaining witness. Ms. Thompson, how we proceed?
The people's necessary witnesses have failed to appear. We have sent subpoenas and attempted to make contact with them, so we expect a motion from the defense.
Motion to dismiss, Your Honor, without prejudice, please, and a copy for my client.
So we have the complaining victim indicated in a letter. That was dated as of August 21st. Right, and then we set, thank you. We set the final pretrial on September 9th. And we're here on September 23rd. We've had unsuccessful contact with the victim.
Yes, Your Honor.
And the victims failed to appear today. The defendants requested a motion to dismiss without prejudice based on the people's inability to proceed. And the motion will be granted. All right, so I'm in possession of the motion for dismissal without prejudice in cases dismissed that has been requested by defense counsel in this matter on 25-02516. Mr. Fowler, this means that the people could choose to reissue if they want to, or if they choose to, but the case is dismissed without prejudice today. I don't have a GPS. I do have a no contact order, so you should carry this around with you for at least the remainder of the afternoon, because it'll take about 4 hours to purge from the system. All right. I will grant the motion to dismiss. Sign accordingly, and then we'll provide you with a copy that you can take with you. Okay, sir.
Your Honor.
Anything else for the record in 25-02516, Ms. Thompson?
Not for the people, Your Honor.
Mr. Ned.
Yeah, thank you.
All right, you should be all set. Thank you for your appearance today, Mr. Fowler.
Is that Richards or Shaw?
Yes. Or what?
Richards or Shaw?
Richards. Richards. Sorry.
Do you represent Shaw? Go ahead and join.
Is Mr. Shaw here? I think he's pro per, isn't he?
Yeah.
What case is this, Mr. Ned?
Mr. Richards.
Daniel Richards.
I paid bond.
All right, so we're on the record in 24-02055 and 24-02056. That is people of the state of Michigan versus Daniel Lee Richards. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Ned.
George Net APD about my client, Sam, am I right?
And sir, you are Daniel Lee Richards, is that correct?
Sure.
Thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how are we proceeding today?
We're moving to dismiss both files based on compliance, but I defer to the defense.
No objection to that, Your Honor. Thank you.
All right, and is the reason for compliance purposes that he's gotten the dogs vaccinated, or is he no longer in control of the dogs?
No longer in control.
All right. Mr. Ned, may I inquire of your client of not being in control of both dogs? All right, so Mr. Richards, your indication is that you are no longer in control and so therefore not the the guardian or representative, and I'll go by the names on the tickets. So you are no longer, so please raise your right hand, sir. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? It is my understanding you are no longer guardian or in control of Remy, the Doberman mix. Okay. Do you know what happened where Remy is? Okay. And you are no longer in control of Area, the Husky Chow mix. Okay. Aria? All right, thank you. And they were, that was also taken by animal control. Is that a fair statement? Okay. All right, I will grant the motion to dismiss without prejudice. On both for compliance purposes. Anything else for the record in 24-02055 or 02056? Ms. Thompson.
No, Your Honor.
Mr. Ned.
Yeah, thank you.
All right, Mr. Richards, good luck to you. You're all set.
Yeah, that doesn't mean anything. That just means that it's going to get adjourned.
Oh, well, we're not gonna pass it. The only question is, I can give you a take on this. Testing positive. She'll never respond.
Sure, but I can't make an argument one way or another about without actually seeing the report.
You want to?
So let me just.
That's all.
Let's ask for a brief.
Yeah.
You're okay with that?
Yeah, no.
Okay.
Yeah, that's fine.
Thank you.
I do this more.
All right, who are we calling next, Mrs. L?
I believe we're ready on Deja Mitz, but she is in the hall. So.
Okay. And we think Mr. Schaub is not, are you Mr. Schaub?
No.
We think Mr. Schaub is going to be a no-show.
Okay.
I think, I mean, I'm guessing, but
You could always keep that one and.
yeah,
figure
we'll call it
out.
last. Let me put those aside. Mr. Schaub makes a big difference in his 5 miles. All right, so we're on the record in docket 21-01767. That is People of the State of Michigan versus Deja Mitz. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the people.
Mr. Ned.
George and the APD about my client's things, am I right?
And ma'am, you are Deja Mitz, is that correct?
Correct.
All right, thank you. This is the time set for a probation violation hearing. Mrs. L, how are we proceeding today? Would you like to defer?
Your Honor, at this time, the people do not have a copy of the probation violation report, or at least I can't find it in my email, so it may have gotten lost in there. At this time, the people would be requesting a brief adjournment to be able to review that report and discuss with defense what our stance would be. I will defer to Mr. Ned for more.
All right, you have the allegations, but you don't have the underlying report. Is
I
that?
think I have either, Your
I don't-
Honor. I
you
had to
think-
ask
okay.
defense for both
All right.
all of that information.
All right, Mr. Ned, is that your understanding?
Yes, Your Honor, we will not object to an adjournment today.
And I think part of when I arraigned you, we made sure we had the proper allegations. Is that correct? Yeah, I think we went through each allegation. Because we weren't certain. There was a 3, a 4, and an 18. Let's see, 3, 14, 3, 14, and then there's a technical violation of 15. So there was some confusion as to the nature of the allegations, because I have 1, 2, 3 that you arraigned on, and then failed to submit to your analysis on August 22nd. That's a violation 15. Doesn't mean there are 15 violations, just means that's how we label them. We should look into this just to make sure. So we will adjourn the probation hearing. I would indicate that Ms. Smith is out of custody, and we'll adjourn. I think we're at the 3 weeks, 3 or 4 weeks, something like that.
However long is.
All right. I know it's not the next 2 weeks, but we probably should set it, probably afternoon. Did you have a preference concerning?
Afternoon is fine.
Because it's a typical probation violation hearing, so I think we generally tend to put those in the afternoon. Yeah, and just in case there's an actual hearing.
1:30 and October 14th.
So October 14th at 1:30. All right, we'll set for probation file hearing on October 14th at 1:30. Mrs. Let us know if you need anything from the probation officer, if you need to contact the probation officer. I remember this case from arraignment, and we were making sure we had the right allegations that she should be arraigned on. Anything else for the record in 2101-767, Mrs. L?
Just that it does look like I am in receipt of that record now, so I will review it.
All right.
Next day. Thank you.
Thank you. Mr. Ned, anything else for the record in that file?
Just a progress update. The day after she was arraigned, she got a really good job at mouthpiece communications.
Okay.
And she'll be following all the orders of probation going.
All right. Make sure your probation agent knows about the new employment, because that might be a part of the update. Thank you for your appearance, Ms. Smith.
Thank you.
I have nothing else. Is Anthony on here?
We don't even have them on the dock.
Oh,
We have Brown on the docket. Who's representing Brown?
I think that's Mr. Harry's.
We have Schaub is pro per.
James Roosevelt?
Not had him check in.
That's Mr. Littlejohn.
James Roseberg.
And and Mr. Roseberg, are those both your clients, Mr. Ned?
Roseberg is mine, Daniel Rich, James Roseberg is mine, Your Honor, and Anthony.
And Darnell Littlejohn?
No.
It's Mr. Harris. And then Mr. Roseberg is not checked in.
Right, we can call that.
Oh, he has checked in?
No, he's not checked in. I don't think he's.
It's 9:30. Let's give him some time. We'll give him till we call the next case.
I'll go find James.
All right. And then, Mrs. Zeller, are you going to be here on Carter and King this afternoon?
Yes, Your Honor.
I don't have any objection to you appearing via Zoom on those.
Oh, thank you.
No, so-
I do. We're about to lose her, Judge.
We need to spend as much time with her as we can.
Maybe she wants to be on Zoom. Have you ever thought of that?
Too bad. Depends on my mood.
Megan, just because just because you have to be here, not everybody has to be here.
We all have to suffer together.
Yeah,
right?
that's what I'm getting. I'm feeling that.
It's a bond.
It creates a bond.
I don't know where I'm
You
going.
muted.
I just am
Yes.
officially not.
All right, so we're on the record in docket 25-00925. That is People of the State of Michigan versus Benjamin Levine. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Levine, who is appearing via Zoom, via Polycom from the Ingham County Jail, Your Honor.
And sir, you are Benjamin Levine, is that correct? Is that a yes, sir? I can't hear you.
Yes, sir, Mr. Flores.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Levine, can you hear me all right?
Yes, I can. Can you hear me?
I can, thank you. Ms. Thompson, how are we proceeding?
We're requesting a final pretrial be set.
And is that a fair statement, Mr. Harris?
Yes, Your Honor, we would be requesting that. I would also like, when given a chance, to try and address bond, Your Honor.
All right. So the final pretrial will be set for
October 14th, maybe.
October 14th at 8:30. So we've set the final pretrials. That'll be live in person on the 6th floor City Hall of Lansing. And then Mr. Harris, you wanted to address bond.
Yes, Your Honor. When I spoke with Mr. Levine, he has indicated that he, to the best of his knowledge, the bonds on his ordinance cases have now even been converted to PRs. Currently, this case is, to my knowledge, the only thing that's holding him, with his bond set at 2010%. He, to my knowledge, I did confirm this with him, he now has a stable phone number here in the area where he can be contacted, as well as a stable address he's staying at on Lowell. I would ask if there, additionally, there is also his father who lives at that address, and who can help make sure he gets to all of his court dates. I would ask if the court would consider perhaps either lowering bond or changing it to a PR bond. Mr. Levine has indicated to me that because of his current indigent status, that he does not reasonably have the money to post the current bond. So I would ask if the court would consider the lowering bond at this time, given that he now has, as I indicated, the stable address, the stable contact number, and for me to get in touch with him, as well as a family at that address who can help get him to his court dates.
All right, and I have bonds set by the magistrate for an attempt R&O and a B&E. It was set for 2010%.
Yes, Your Honor, that is my understanding as well.
All right, and then I failed to appear out of May 13th. I failed to appear out of June 10th. With two previous filled. So I'm going to take a statement from you in a second, Mr. Levine, but those are correct. I have those as two previous failed to appear. Ms. Thompson.
Well, due to those prior failure to appear and an assaultive crime, we're asking that bond remain the same at this time.
All right. Mr. Levine, anything you'd like to say on concerning this? And I know, and Mr. Harris may indicate that you shouldn't speak anymore, but anything you'd like to say, and then you may get cut off, Mr. Harris, if you're saying something about the facts of the case. You shouldn't say anything about the facts of the case.
I'd like to do is I'd like to let you. I'm getting my life together. I have a job. I have everything I need, just like I have a phone number now. I have an actual legit phone number. I have a legit address. I have people that are willing to take me to my court dates and all that stuff. I needed to be able to fight these cases now too. I didn't even have all that before. I finally got making my whole email. I got into everything I needed to find out. And the only thing stopping me from being able to finish taking care of the stuff is being stuck in here. I have a job. I'm my job right now. And everything in my life together. And that's why I threw myself in Eaton County to go and take care of these cases.
Okay, you were self-employed previously. What is your new job?
My job is actually doing property cleanouts and stuff like that.
Okay, so is that a self-employed job, or are you working for a business, sir? Are you working for a business?
Yes, I am.
And which business?
Restless Contracting.
Okay, what's the name of the business?
Restless Contracting.
Right, we'll update that.
And I'm trying to get back out there to my job before I lose it completely from being in here.
At this based on time, at this time, based on the prior bond set by the magistrate, I'm going to deny your motion.
I have $70 for my bond right now.
Well, you're going to need $200 because it's set at 2,010%.
$70 on me to reduce it.
All right, thank you. I've denied your motion. You should be all set, sir. Thank you for your appearance today.
Why are you being like this? What I do? I'm doing everything I'm supposed to do, and you guys are still fucking me in the ass. Why?
I think we're muting you is what we're doing. All right. So my decision's been made on that case. Should we call Mr. Schaub? All right. And then Mr. Littlejohn is also, oh, Mr. Littlejohn's here. You should, this will give you the time to meet with Mr. Littlejohn. We have Mr. Brown as Mr. Harris. All right, we get a bunch of. No, I think he was.
No, he was in bench warrant status.
He was in bench warrant status, and then that's how we got him here. Because did we set it for final pretrial today?
I think he got a rating and they
Yes.
said,
Yeah, they said it.
They said it, and they're all dog cases, I think.
I have a feeling he just doesn't care. Really?
I have a feeling you're right. All right, we'll call Schaub after I mark all these files.
No Roseburg either. Probably. For this file,
All right, so we're on the record in dockets 2202-821, 2202-822, 2202-823, 2202-824, and 2202-825. That is People of the State of Michigan versus Randolph Schaub. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
All right, thank you. This is a time set. 8:30 was previously set for the pretrials. It is set for 8:30. It is now 10:02. And it would appear that the defendant has failed to appear for the pretrial. I do not see, and being somewhat aware with Mr. Schaub, who's been here. Well, we bench warned him, so he's been here. I do not see Mr. Schaub in the Zoom courtroom, physical courtroom. We'll call in the hallway just because there's 5 files. So we should be here in the next 5 minutes. Mr. Schaub here? No, there's nobody by that name in the hallway. Attorney Georgeson Ned was nice enough to call in the hallway. Therefore, it appears the defendants failed to appear for the pretrials on all these files. That's 21, 22, 23, 24, and 25. Ms. Thompson, how are we proceeding?
We're requesting that an immediate bench warrant be issued for
All
Mr.
right.
Shaw.
I have a previous fail to appear on April 29th. I'm sorry. I have 3 previous fail to appears dating back to November 28, 2022. It would appear that I think we've tried a 48-hour hold before. We only see Mr. Schaub when he seems to be, brought over. So I'll issue immediate bench warrant on all these files for Mr. Schaub. Anything else for his fail to appear at the final pretrial? Anything else for the record in dockets 21, 22, 23, 24, 25? That's 2202-821 and the accompanying files, Ms. Thompson.
No, Your Honor.
All right. There's 1. I'm just gonna count. Or else,
I can write if you want.
no, I'm fine. We have some time.
Yeah. I'll tell you what. Were canceled before dispatch. I don't know. It's a really an argument. The only difference is what the under cost and what they could charge in the future. So he's playing, and I tried it. Yeah, he wants to.
So your advice was to run a pointless trial?
That, but he wants to take the plea.
Well, yeah, that's fun. Because instead of going for the retail fraud second, when she's charging, getting your plea.
Yeah.
Those shots. So you want to go on Mr. Roseberg?
I believe Mr. Annette was going to try to give him one more phone call.
All right.
Oh, apparently not, just kidding.
All right.
Oh, I'm sorry, I'm trying to figure out something.
James Roseberg. Pretrial and consent. All right, so we're on the record in 25-02270. That is People of the State of Michigan versus James Roseberg. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Gazelle, Assistant Prosecutor for the People.
Mr. Nett.
George Nett, APD, my client is not here today.
All right, this was set for, it was set for pretrial and a contempt hearing. Let's see the nature of the contempt. It's a retail fraud on Mr. for the contempt hearing. So so this set for pretrial contempt hearing, Ms. Azell, how are we proceeding?
Your Honor, it's my understanding that the defendant is not here today. Based on that and based on the underlying file being an assault and battery charge, we would ask that a bench warrant be issued in this file.
Mr. Ned,
No comment, yeah.
I have a previous bill to appear on August 12th.
I know records indicate that as well.
Your records indicate what?
Yeah, he also failed to appear on
Yeah, August 12th. I don't have a fail to appear after that. I do have a violation, a contempt violation. It looks like a retail fraud. I'll issue an immediate for the fail to appear. I do not see Mr. Roseberg in the Zoom courtroom, physical courtroom, and nobody responded by the name in the hallway. Based on the representations of counsel, the defendant has failed to appear for the contempt hearing and the pretrial. And we'll issue a bench warrant on both those files. That'll be an immediate bench warrant for the prior fail to appear. Anything else for the record in 25-02270? This is up.
Not for the people.
Mr. Annette,
Oh, yeah, thank you.
you should be all set.
I think that's it for today, right? All right, I will see you guys when I see you.
All right. We'll see Mr. Annette.
You don't need to be here for the afternoon again.
I don't think so.
And I have Carter and King this afternoon.
What's the first names?
Joshua Carter and Billy King. All right.
It is the same.
All right. Mr. Harris is here. I think he's speaking with Mr. Littlejohn.
You get a bench. You get a bench warrant. Everyone gets bench.
What do you got here, Megan?
Bench warrants.
Is Jimmy Brown still on the docket for today?
He
I have-
is,
and
so
I have Mr. Harris.
I don't know if he, not to,
You don't know if he's showing up?
Well, that, yeah. He has a bunch of other dog licenses set for the 14th, but then this one was set for today. So I don't know if he got his dates confused.
Oh, I believe.
He's got like 2 or 3 other dog
Okay,
tickets.
I think
for the
Mr. Harris
14th.
is under the impression that it would be moved to the 14th as well.
All right.
But
Well, that would
we'll
have
confirm when he
if
comes in.
there's no objection, that will just move it on to October 14th.
John Liz dog file for today.
Exactly.
I noticed that when I was prepping the docket too. I was like, why is this one set for today and then the others are set for the 14th?
That is a good thing to look at.
The dog.
Oh, gosh.
Judge Simmons back.
Okay.
That would be fun that what you think you're getting is Judge Simmons and then you actually get Judge Simmons. That would be good times for all.
Yeah, so the argument is that the
Those are getting to be expensive dogs. Doesn't matter, he gets picked up and he gets a PR.
The one that actually talks about the dangerous animal. All the provision that we have cover what animal control would be established in. So their argument is that when the dangerous animal was established, animal control.
Oh, no.
Make
I figured
the rule or like make the new law.
I'd have some time to
That's kind of what they're arguing. They're saying like they no longer have that power.
do whatever I need to do.
And so then.
Anything, or you tell me if anything was urgent.
I have not done any necessary. But it would still have to be able to function.
Okay, so I think that's the argument.
Oh, yeah, okay. So are they basically saying that it doesn't put it?
I thought and stricken saying it's.
Okay.
So it's really a constitutional argument, like balancing powers, separation of powers. To go along state constitution class, right, that's pretty much all we talked about, it's like state constitutions, and this was actually something we talked about in the law. Yeah. in terms of state classes.
See, because like in general, every time I take they're just pulling in all the pieces that you don't know even about. It's like equal protection, like, but then it's like I get better remember. Like it's really speech and I can just like I get it and so the procedure like separation and laws statute and everything, but then it's in conflict with something. I was just like telling about it.
I am really good at remembering the small details of cases. And you could start telling me if I'm familiar with the case and I would know a lot about it. But if you try to be like, do you remember this case and then you say the name of it?
Oh no, I'm the same way.
Like,
yeah, and I was looking at my friend that just started with problem. I was like telling my aunt he was losing it. He's like, that's Spider-Man. Until week 3, where you realize none of this matters, like erased. And so I like showed him that, and then he was lawyer, and I literally could not in my head think of what money told him. Oh, yeah. Exactly. So, just give me the facts.
I'm gonna see.
What's do they say that?
He's from
They
55.
want to split into 10.
The defendant may be a city of Lansing resident, so it was committed here. The Tri-County Metros, because I got one from Rivian Township, or that's the only thing I can think of. Or you can't get a hold of the judge. So. Which is what launch distance are doing. You go to another district. We used to go to Clinton County all the time. The Tri-County Metro, we could get anything. That was like.
As a heads up, I think it's gonna be a minute.
What's
Okay,
that?
I have to go.
Seems like it's gonna be a minute.
Mr. Littlejohn?
Yes.
Judge, we're not muted, just so you know.
that we can go ahead on Little John. Mr. Little John is here in
All
the
right.
courtroom. And then if we want to put Mr. Brown's case on the record for that adjournment.
All right, let's go on Mr. Little John and then we'll go on. And Mr. Harris is the attorney, correct? All right. All right, so we're on the record in 25-01955. That is the people of the state of Michigan versus Darnell Littlejohn. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Darnell Littlejohn, who is standing to my right, Your Honor.
And sir, you are Darnell Littlejohn, is that correct? Thank you. This is the time set for a pretrial today. It's a pretrial, yes. Ms. Thompson, how are we proceeding, or would you like to defer to Mr. Harris?
I'll defer to Mr. Harris.
Mr. Harris.
Yes, Your Honor. At this point, we would be requesting a final pretrial be set on this file. I have spoken with Mr. Littlejohn regarding the allegations and regarding the offer. We would ask that the court set for final pretrial, 1, to give me some time to go over some additional discovery I have, and 2, to give him some time to consider the offer, Your Honor. Thank you.
All right, and so we'll set for final pretrial on.
October 14th at 8:30.
And are we expecting witnesses here, or is, I'll make it all, or, so if there are no witnesses, Zoom's appropriate, but it'll be for all the defendant and witnesses. So do you expect witnesses here?
Your Honor, it's a retail fraud. We usually don't have the
Okay,
loss
that's
prevention
not-
officer come in.
All
If
right.
the defense is, it was requesting it, we could always ask them to come in.
All right, so we'll make Zoom appropriate for all. If they want to come in, and defendant. So Mr. Littlejohn, you can attend via Zoom that, or exactly like we're here today on the 6th floor.
Yes, sir. I would love to be in your presence.
I can't say that about everyone. All right, so we've adjourned this to October 14th at 8:30. Anything else for the record in 25-01955, Ms. Thompson?
No, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Mr. Littlejohn, we'll see you on October 14th at 8:30.
Thank you.
Thank you.
I just think I'm starting to rub off on you.
Why is that?
Say what you're thinking.
Yeah, it's not always a good thing to say.
That's what I wanted to make sure.
You're like, you need.
Or- After 4 years or 3.5 years, you get a little more, maybe too comfortable on the bench. Judge Brown, I was in front of Judge Brown. He used to say things on the bench. I'm like, I don't think you can say that. I don't think you're allowed to, but he'd been on the bench for 30 years. So I mean, I was like, yeah, you can say whatever you want. I just because you can doesn't mean you should.
Yeah.
It's comfortable.
All right, so we're on the record in 25-02336. That is people of the city of Lansing, people of the state of Michigan versus Jimmy Brown. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Jimmy Brown, who is not here, Your Honor. Regarding the failure to appear, I was unsure if Mr. Brown properly had noticed or was aware he needed to be here. My understanding from Mr. Anid, who handled this case on my behalf last time we were here, is that all of the cases were set for October 14th.
I think that's true because I have on September 9th, I have in my note is if we've set it for October 14th at 8:30.
Yes, I think perhaps it may have, and this is simply me speculating, it may have originally been considered for 9/23,
right.
and then one of the cases may not have been removed. I'm not sure. All I know is that my understanding is all of the cases were previously set for 10/14. So I think it being scheduled today may have been a bit of an error or oversight.
I would agree. It's an unlicensed dog case. Do you have any objection to me resetting this file for October 14th so we can handle it all together with the other files?
No, Your Honor.
All right, so we're gonna reset.
Yes, I believe according to the court's website, it should already be set for 10/14, Your Honor.
Okay.
That's from looking at JIS, Judge. That was my error. I did not adjourn it, or I thought I adjourned it and it didn't come off. It could have gone either way.
All right, so let's reset for October 14th at 8:30. Anything else for the record in docket 2502-336, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Nothing for the defense, Your
All
Honor.
right,
Thank you.
thank you. All right, that is the morning docket.
I will be back for Mr. Carter in the afternoon.
All right, now we've got Mr. Carter and we've got a second sentencing.
Really,
Yes.
being handled by Mr. Woolley.
Okay,
Yeah.
and one of those has failed to appear for their
Mr.
pretrial sentence, for their updated report.
Yeah, and I believe Mr. Carter did appear and will be coming here later today. I did get a PSI that was largely what I was expecting.
Okay.
And hoping for.
All right. Well, we'll see you this afternoon. Thank you, everybody, for your appearance today.
All
Thank
right.
you, Your Honor.
Mrs. Zell, you can come via Zoom if you want.
Thank you, Judge.
Okay. All right, Mrs. Zell, you're here on Zoom. You're here for Mr. King and Carter. We'll do King first because that's the fail to appear. That's Mr. Woolley. So we are on the record in docket 25-00467. That is People of the State of Michigan versus Billy Bernard King. Appearances for the record, Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Woolley.
Good afternoon, Your Honor. Lionel Woolley on behalf of Mr. King is not present.
Right, this is the time set for a sentencing today. It was set for 1:30. It is now 1:56. And it would appear that Mr. King has failed to appear for his sentencing based on the representations of counsel. And I don't see Mr. King in the Zoom courtroom. Is there anybody, a representative for Mr. King in the physical courtroom? There's nobody in the hallway. Mr. King also missed his pre-sentence interview, so we had nothing to sentence him on, really. And Mr. Woolley, you've not had any effective communication with Mr. King, is that correct?
I have not, Your Honor. The number that I have with him that I also confirmed the time that we did the plea back on July 22nd of 2025 is not operational, and the letters came back. He did indicate to me at the time that sometimes his mail goes somewhere else, but all the letters that's been sent to him has been returned undelivered.
So at this point, in order to get Mr. King here, the defendants failed to appear for the sentencing, and an immediate bench warrant is issued for their arrest. Anything else for the record in 25-00467, Mrs. Zell?
Not for the people, thank you.
Mr. Woolley.
Your Honor, I would just ask that if this could be held, for 48 hours until, I know this is for sentencing and he failed to appear, just so in case that he shows up late or by any grace of God that he ends up coming.
I would, except he failed to go to his pre-sentence, so
right.
He'd be remanded anyway today. If he was able to show up, he'd be remanded for the pre-sentence anyway. So with that understanding, no, Mr. Woolley.
Appreciate it, Your Honor.
Thank you for asking. Okay, so that's all for the record in 25-00467. And then Mr. Harries, are you ready on 25-01774?
Yes, Your Honor.
Yes. All right, so we're on the record in docket 25-01774. That is Joshua Carter, People of the State of Michigan versus Joshua Carter. Appearances for the record, Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
All right, and Mr. Harries.
Assistant Public Defender James Harries here on behalf of Mr. Carter, who is standing to my right, Your Honor.
And sir, you are Joshua Allen Carter, is that correct?
Correct.
Thank you. This is the time set for a sentencing today. Mrs. Zell, is there any further restitution in this matter?
There is not, Your Honor.
All right, thank you. Mr. Harries, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, I have. But at this point, we have no additions, deletions, or corrections.
All right, allocution, Mr. Harries.
Yes, Your Honor. I will start by indicating that Mr. Carter is apologetic. He does, at no point has he tried to fight this, to run from this, to try and avoid responsibility. He's shown up to my knowledge, I believe he's shown up to every one of his court dates, and he is trying to take responsibility for the actions he took on that day. When I spoke with him regarding this case, and when he spoke with probation, there is an indication that he acknowledges and is aware that the actions he took on that day were not correct, were not reasonable, and that even in the frame of discipline, which he does not claim this was, even in the frame of discipline, he is aware and acknowledges that he is not the proper person who should be disciplining anyone, as the child is not his. He is fully ready and willing to comply with the recommendation and the terms of probation that this court could order. I believe that those terms of probation could be very beneficial to him for helping deal with the anger and mental health issues that he admitted he has been dealing with, and that probation has crafted the recommendation to solve. I believe that Mr. Carter would be a good candidate for probation, and I would ask that the court follow the recommendation. When I was reviewing the recommendation, both before court and with Mr. Carter, to me, 24 months of probation seems a bit excessive, in my opinion. I would ask if the court would perhaps consider 12 months, both because of, well, partially because of the financial burden of 24 months at $30 a month probation oversight. Mr. Carter is currently on a very limited fixed income. He is not employed. He's currently in the process of trying to get approved for Social Security disability payments. And I did speak with him regarding that, and he is willing and able to provide any verification of that once a decision has been made regarding the recommendation of probation that he obtain or maintain employment. And further, I would ask if the court would consider not ordering the random PBTs and or urinalysis, as per my review of the case and the information in the PSI, there was no indication anywhere in the case that drugs or alcohol played a factor in the events of this case at all. This seems to be a situation that happened due to, as probation determined some, and as Mr. Carter has previously mentioned, some anger issues and some mental health issues that I believe could be otherwise more properly managed through the anger management classes, the moral recognition therapy, and the mental health treatment that is recommended. So I would ask if the court would also consider not ordering the random PBTs, as that would also be an additional fine that Mr. Carter would have difficulty reconciling with his limited income. And so I would ask if the court would consider not ordering that, because I don't believe there are any rehabilitative goals met by random PBTs or drug and alcohol testing, Your Honor. Regarding fines and costs, I would ask if the court would err on the lower end of fines and costs for this case, as even with 12 months, let alone 24 months of probation, with the $30 a month probation oversight fee, that's looking to be between $360 and $720 in just the probation oversight fees alone, which combined with, so I would ask if the court would consider lower fines and costs so that any resources that Mr. Carter has can be more appropriately put towards the probation oversight fees and the programming, as there are 2 to 3 terms of programming that Mr. Carter would be recommended. So I would simply ask if the court would consider following the recommendation with the minor change of considering 12 months instead of 24 months, and considering not ordering the random PBTs, Your Honor. Thank you.
Thank you. Mrs. Zell, is there anything you'd like to say to on behalf of the people of the state of Michigan concerning this matter?
Yes, Your Honor, if I may. I would just like to say that the people would like to ask for a brief period of upfront jail in this. Due to the facts of the case, this was a pretty egregious assault and battery case. One, we believe it was premeditated. Rings were taken off before the actual assault occurred. Second, the assault happened against an 8-year-old child. This led to probation calling Mr. Carter an inherent danger to children in their report. Additionally, Your Honor, against what Mr. Harries was saying, the probation report does also show that there was a clear lack of moral reasoning and moral recognition of what happened. Unlike what Mr. Harries said, I believe in this report, Mr. Carter said that the 8-year-old boy deserved to be hit, and also showed a lack of remorse. Additionally, Your Honor, we do not believe that any period of probation, including the 24 months, would be excessive if jail time is not sought here. There's a prior history here of Mr. Carter not only putting children at risk of harm, but actually harming those children. We would ask that this be considered for a upfront jail time. Additionally, Your Honor, if upfront jail is not considered, we would ask for some sort of GPS monitoring to ensure that Mr. Carter is not attending places where children are typically there playing or with their guards down, such as playgrounds or schools. As again, we believe Mr. Carter does pose a risk to children's safety in this community. With that, Your Honor, we would ask that the recommendation not be followed. Thank you.
Thank you.
I may briefly respond.
After Mr. Carter.
Understood.
Mr. Carter, the court would like to hear from you concerning this matter.
I admit to everything that is been said about me and accused of me. I do not believe that I pose any other risk, as that I'm also seeking further mental health treatment and programming on my own. I've already increased the amount of times that I go see my therapist from bi-monthly to bi-weekly. I am seeking out further mental health treatment in anger management and cognitive therapies.
All right, Mr. Harris.
Yes, Your Honor, regarding the statements regarding the statements of there being a clear lack of moral reasoning here, I would simply point out that that seems to me to be the exact scenario and situation that the more recommended moral recognition therapy is designed to resolve. Furthermore, I would, regarding Mr. Carter's prior criminal history, I would simply indicate that that as Mr. Carter described to me previously, those matters, while he is not trying to dissuade or minimize, he has already been punished for, he has already served his time for, he's trying to make an attempt to turn his life around and put the person who he previously was behind him. At this point, Your Honor, probation had all of the information that both myself and the prosecution have today, and probation did not recommend any upfront jail in this situation. Probation seems to be of the belief that Mr. Carter would be a good candidate for probation and could learn a lot from probation, gain some structure, some support, and could learn better, healthier ways of dealing with his anger. So I would ask if the court would simply follow the recommendation here, Your Honor.
Thank you. Well, I've had the opportunity to see the pre-sentence. This is for a guilty plea for July 29, 2025 to A and B battery involving the victim in this matter. The victim is, I believe, the biological mother of the 8-year-old, although the 8-year-old is not your son. Is that correct?
Correct.
All right. I will also indicate the reasoning why in an issue of transparency, where why I'm not following the 24-month via probation, okay? 24 months probation. You have an A and B out of 2004. You have a CSC out of 2005, and the victim of that was 12 or under, okay? Also, it's been my experience that usually plead to a CSC because you pled it down from something. So it's a CSC first, or it's older, you plead it down. That's been my experience. That may not be the case here, but you made a factual basis for pleading to CSC second under the age of 13. That was the victim. You also you're on the Sex Offender Registration Act. I would agree with Mr. James. I'm with Mr. Harris. I don't believe this is a drinking situation. And I don't believe this is a bars or nightclub. I do commend you for going and getting some attention towards the more recognition and mental health counseling. But I'm not going to make it part of this probation. Okay. What I'm going to do today is give you jail time. I'm going to give you the ultimate jail time that I can give you. So you'll be off the streets and you won't be a threat to any other children in our community. That's what I'm going to do. Because This is not your run-of-the-mill assault and battery. This is very different from that. So I'm going to sentence you based on the guilty plea of July 29, 2025 to 93 days in jail, credits given for 2 days previously served, and you're to spend the 91 days remaining in jail in the Ingham County Jail, and you can go with my court officer. Good luck to you, sir. And I expect this not to be an early release situation.
Yep. Yes. You guys have everything I have except for my land.
Okay.
You too.
Yeah, well, I need it to look pretty.
We're not even gonna put this in, because that's gonna confuse the
I just
powers
got
that be downstairs.
CJOS on that, and then you can make
We're gonna write in the file, the court file when you hand it to me, and we're
I
not
just
gonna
said-
confuse Susie,
yeah.
and you're gonna sign it.
All right, Mrs. L, thank you for your appearance. You should be all set.
Thank you. Have a good evening.
Thank you, Mr. Harris.
Thank you, Your Honor.
Well, that's a tough one.